Gilles Bissonnette, ACLU, New Hampshire, is going to talk about whatever he feels like talking about.
Thank you, Nancy. So my name is Gilles Bissonnette, legal director for the ACLU. So Nancy writes about the government for a living, and I get to sue the government for a living. So it's I do think it's the best job in the world. And this discussion has really gotten me thinking. I actually think one of the biggest obstacles to knowing what the government is doing is how our public records laws are interpreted right now in the state of New Hampshire. In fact, how our courts have actually whittled away at some of our very significant transparency protections that exist under Chapter 91. And there's two examples I want to get to, and I will. One of which is actually the Laurie case. That's my second example. But if you've ever read the newspaper and you're reading a piece about government behavior, you'll often see a government agency respond that we can't comment on that because it's a personnel matter. Have you all seen that in the paper time after time after time? So what is actually going on there is you have a government agency effectively relying on what's called the internal personnel practices exemption. And I can just tell you that in my practice, this is the most overused exemption that government agencies routinely rely upon to hide valuable information from the public. Information that would expose information that is in the public interest and would help all of us hold the government accountable. So why do government agencies cite this exemption time after time after time? They do so in part because of a state Supreme Court decision 26 years ago called the Fetterman decision. And it applied this internal personnel practices exemption to individual government employee information and applied it categorically, regardless of whether there's a public interest in disclosure, regardless of whether the privacy interest is minimal, regardless of whether or not disclosure of that information would ultimately expose misconduct. That is devastating for government accountability. I can't underscore it enough. It is absolutely devastating. And so what have we seen in the newspapers in the past several years as a result of this interpretation of this exemption? Information from the Manchester Police Department concerning the termination of former Officer Darren Murphy was later disclosed that he was accused of coercing women into sex. Ultimately, though, no criminal charges were brought. Reporters sought access to information concerning those allegations. No internal personnel practices exemption. I think it's vital for Nancy's work, it's vital for the Civil Liberties Union work, and it's vital to us as the public. We need to have accountability. We need to know what the government is doing. And that leads me to the Laurie case. Nancy asked, as many reporters have in the state of New Hampshire, for the Laurie list, what's now called the exculpatory evidence schedule. It's been given a clever new legal name. It's a list that's maintained by the Department of Justice, over 260 officers on that list where there's been a sustained finding of conduct that relates to their credibility and truthfulness. And listen, police officers, they do important work. We all understand that because they risk their lives. But they also have immense power, right? They can use lethal force, they arrest folks, and they're professional witnesses in court, different than you or I. They have this additional responsibility in which their testimony goes a long way, and their testimony can be used to deprive individuals of their liberty. And so with that really comes a higher standard. Their credibility, their truthfulness really matters. And so this list is really important because I think it's important for people to know whether or not an officer is on, people in individual towns, it's important to know whether or not officers in their community are on that list. It's also important for defendants to know whether or not officers in their cases are on that list so they can, through the criminal justice system, vet that officer. That's how trials work. That's how justice is served, through that adversarial system. But no, this list is secret. Fortunately, a Superior Court judge disagreed with the Department of Justice's position and said, no, that's not a personnel document. That document doesn't really have anything to do with human resources or termination or discipline or employment. That document has the separate function, so it falls outside of the internal personnel practices exemption. That's some of the work we're doing, and I want to give a huge shout out for Nancy. Nancy has been working on the Laurie story for years, I think as she said, since 2012. And her work is, I think, so important on this issue, and really caused me, frankly, to become interested in it and to want to work on this project on behalf of In Depth New Hampshire and the civil liberties unions.